Welcome to Common Sense. The Common Sense program is a series of shows that feature interviews with very interesting people so that we can learn in a clear, concise, and direct way who these folks are, what they do, and what's making sense to them and what doesn't. I'm Rudy Breglia, and today I'll be interviewing the knowledgeable, wise, and friendly attorney and owner of Barron Law, the one and only Dan Barron. Dan, welcome to Common Sense show, and please start us off giving us some background, where you were born, what brought you to this part of Ohio.
Sure. Well, Rudy, thanks so much for having me. Okay. I'm Cleveland, born and raised. Grew up in Valley View, and I guess you can call me a townie because I never left.
Oh, okay.
Yeah. So I wasn't always a lawyer. I started a landscaping company when I was 12 years old, going door to door.
Oh, wonderful.
And so that grew into a pretty big business, but stayed close and went to law school, and so now I live in Richfield and work at Independence, Beechwood, Westlake are our offices. So,
okay. Well, what made you decide to be an attorney? Did you have a role model?
So, I'm first generation lawyer in my family, but a couple of things. One, I found myself in the middle of the night, and of course, northeastern Ohio weather, snow plowing, and I just decided, I really don't want to do this anymore. And so I finished my undergrad and went to law school. And at the time, I didn't know exactly what kind of lawyer I wanted to be. But there's some things going on in my family, with my grandma. And as everyone could appreciate, there's a couple things that are certain, and one of them is death.
Uh-huh.
So, we went through some things, and that really drove me to focusing on estate planning. In terms of a role model, I'd have to say my dad.
Okay.
So he, not an attorney, but one of the smartest people that I know, who worked blue-collar jobs his whole life.
Okay.
And so his work ethic, definitely instilled in me, and so he's my role model.
Okay. Well, what are the qualities that make a good attorney?
I think it depends on what kind of attorney that you are. If you're a litigator, then, maybe someone who's aggressive and, someone sharp and quick, like you see on TV.
Okay.
But, for what I do, I think you have to have a lot of compassion and, understanding, because you're dealing with people who are going through a tough situation. And, but overall, I think for every attorney, whether it's a divorce or criminal, or what have you, ethics are number one.
Okay. All right.
Character, and just, really doing what's best for the client, because that's your job, is, the client's number one.
Okay. What's a typical business day like for you?
So, typical day would be handling a variety of things. We're helping clients on the estate planning side, wills, trusts. So you'll meet with someone, and maybe it's a young couple, they're just getting started. Maybe it's an older couple, and they're or their kids who are planning for their parents. So that's kind of on the planning side, and wills, trusts, things like that, powers of attorney. But then there's the other end of the aftermath. Maybe someone passed away, there's a trust administration, and so you're helping the family navigate that. And most people don't do this on the day-to-day, so you have to hold their hand of, okay, you have to go to the bank and open up this account, liquidate these assets. And so you're really navigating every day, start to finish. And on a given day, we'll have 100 to 150 different cases that we're working on, and some are easy, some are complex. But there's one common thing: is it's hard for the family to get through some of those things, and so we help them.
So your specialty is kind of geriatric law. Am I coining a term, or?
I think I've never heard that term, geriatric law.
So just came to me. Okay.
Yeah. I guess synonymous with elder law. So estate planning is planning for death or incapacity, and that's our bread and butter, is doing that. Then you have probate if you've done no plan at all, or if you're relying on your will you're going through a court system, and so we help people with that. And then geriatric law, elder law, that would be, helping people that maybe nursing home or assisted living, a long-term care facility, if that's in the picture.
Okay.
And to help protect assets through a trust or maybe Medicaid planning. And then finally, business succession. So a lot of our clients are business owners.
Sure.
And I'm a business owner myself. And any entrepreneur out there, the main thing they're focused on is growing their business, right? And they're not really concerned about what happens
afterwards.
And those are the biggest messes I think we have. So we help business owners, plan for succession as well.
Okay. Well, I know the answer to this question, but I'm going to ask it anyway. How trustworthy are low-cost legal forms for wills that are freely available on the web?
So overall, not trustworthy at all. And I have maybe a couple horror stories for you, but I'll start with some of the things that are okay. Some things you don't need a lawyer for. And for your healthcare power of attorney and your living will, here in Cleveland, we have Cleveland Clinic, and it is okay to use those forms. You don't necessarily need a lawyer for those, and they're supposed to be okay state by state. There is a universal statute. However, if you have a house in Florida that you go to, you should get Florida forms as well. Aside from that, you definitely should use a lawyer. Case in point, example, client right now, there's 5 siblings. Mom wasn't doing good. She had her son go online and do a will. He had it notarized. Well, he didn't do it correctly because in Ohio, you have to have 2 witnesses. So since it wasn't executed correctly and he did the legal Zoom thing, it's thrown out. It's not good. And so now the whole family is fighting because her wishes would have been met and it was properly notarized, but that's not the proper way to do it.
Oh, that's too bad.
So to answer your question on that, no. I mean, I use the WebMD example. Anytime if I have an ailment or something, and if you go on WebMD and all of a sudden it's telling you have cancer and you don't, get a professional to get it done. Don't rely on do-it-yourselfers from online.
Okay. How many offices and attorneys do you have in the company?
Yeah, so we have 2 attorneys right in-house, and then we have 3 of-counsel attorneys. So that just means that they're their own firm, but we work side by side with each other. And then we have 5 or 6 staff members, support members as well. So we're kind of a smaller firm, but larger than just a one-man band. And our main office is in Independence. That's home base for us. We have some satellite offices in Westlake, Beechwood, and even a couple in Columbus. So I'll meet our West Siders, in Westlake, and East Siders in Beechwood. So I bounce around between offices.
Okay. What is your motto, and what do you exactly mean by that?
So a couple of things. So I'll start with our mission, which is seamless client service through a comprehensive approach. And so, the big law firms, it's not so seamless. You have to get through 3 different people to, get things done. And so that could be challenging. With us, we want to make sure that if you call, you're going to talk to someone, right away. Okay. And if attorney isn't available, then, no problem. You're always going to talk with someone. Our motto, long live peace of mind. So, estate planning, it's something that's changing. And, your plan when you're in your 20s or 30s isn't going to be the same plan that you have when you're in your 70s
Absolutely.
or 80s. So, things do change and you have to update your plan. And so it's important to meet with someone so that you do have that peace of mind, forever. You don't want to leave your family in shambles or having to pick up the pieces through probate court.
Understand. Well, we're going to cover a lot of ground in this interview, and it's a lot for people to absorb. But at the end, we're going to have our emails at your email and your website at the bottom of the screen, and people will be able to go and learn about what we're talking about today. Tell us about estate planning. When should it be done, and why is it so important?
Well, when do you plan on dying?
Yeah. There's no schedule.
No, it should be done the moment you turn 18. It doesn't. You don't necessarily have to have this elaborate, complicated plan, but even an 18-year-old that's in college, they should have at a minimum their advanced directives so that their parents can get access to their medical records. If they're in college, they have no access, their parents have no access to grades or can't make decisions. So, like I was alluding to before, your plan changes. You should start now. And, generally speaking, you'll review it, every 10 years because your circumstances are going to change. But it's very important. Your circumstances, as they change, you may have a very unintended result when you get married, have kids, and so forth. So
Okay. And you've used this term already. What is probate, and how long does it typically take, and how much does it cost, that kind of thing?
probate is a very misunderstood concept. It is a court. So every county has a probate court. And it is a means to get assets from the person who passed away, the decedent, to the heirs. But probate is highly inefficient. It's very expensive because there is a judge. There's no jury, no one's on trial, but there's this whole process. And the reason you want to avoid probate court is cost and efficiency. The minimum time is 6 months. So if you can imagine, even if you're married, hypothetically, husband, wife, and husband passes but has a bank account that's only in his name, or has a piece of real estate that's only in his name, the spouse does not automatically inherit that. And so it has to go through this court system, and it takes 6 months to a year. If you have a will, even with a will, it still goes through probate. So in that example, that spouse can't just go to the county and say, hey, here's my husband's will, go ahead and put the house in my name. It will take 6 months to a year. Now, that said, probate, although inefficient and costly, having a will is still better than no plan at all.
Sure.
Before I came to this meeting, I was on the phone with someone, and he was the son of his father who passed away, okay? Well, his father remarried, and there was no will. And so she, legally, is only entitled to half. I don't know what his wishes were because he passed, but if he wanted everything to go to his spouse, all he had to do was have a will. Sure, it would have taken a year, but probate, to answer your question, probate's a court system, and you want to avoid it. It takes a long time. Cost-wise, just to give you an idea, attorneys actually make more money in probate than they do to try and...
Yeah.
We get paid on a percentage, like a real estate agent does on selling a house. So, and typically most attorneys will take the greater of either an hourly or the percentage. So you could do the math. If there's $1 million in an estate, that's quite a bit that's going to the attorney, and then also the court fees and everything else.
Okay. Well, I'm going to give you or show all the viewers graphic C, which has the critical legal document that everyone needs for proper planning, and they're listed. And what I'd like to do is maybe key you on certain of those documents, and then if you could explain them, that would be wonderful.
Sure.
The first one is, what is a simple will and what is a living will? And those are listed on that graphic.
Yes, so often confused. So a will, or AKA a last will and testament, that is defining who gets what and who's going to be in charge.
Okay.
And so again, a will doesn't avoid probate court, but it's better than no plan at all because you can make those decisions through your will or last will. Otherwise, you're leaving it up to the state.
Okay.
Okay. So I always say, if you don't have a plan, the state has one for you.
I see. And they're happy to present you with it.
Yeah. A living will is totally different. It only has to do with incapacity. So if you're in a permanent, irreversible vegetative state forever, and if two doctors determine if you're in a permanent, forever vegetative state, a living will says that you're making the decision today to ensure that your loved ones don't have to make that decision later to pull the plug. So if you recall Terry Schiavo, that example from Florida, young girl, she was in a coma for like 6 years. If she had a living will, it wouldn't have drug out for 6 years because she would have said, hey, if I'm in a permanent, forever vegetative state, I'm pulling the plug myself.
Okay, all right, understand. The next term that's in there is, what is a HIPAA authorization and why is it important? And if you could explain what HIPAA is.
Yeah, so acronym Health Insurance Portability Act. So it's mainly privacy laws. And so this is a big thing since 2012. Anytime you go to the doctor or, you got to sign a HIPAA. And it essentially, without it, your family or loved ones, they can't get any access to your medical information or records.
Okay.
And so by creating this document, it's very important, especially for college kids. If you have kids in college, get this established because that will give you access to their medical information and records. Just a quick story, have a client, her son goes to University of Michigan, boo, Ohio State fans. So, and you could share your location on your iPhone. And so she checked in and saw that his location was at the hospital. And so she calls and says, hey, tries to figure out, well, of course he doesn't answer. She calls the roommate, he doesn't answer. She calls the hospital and she knows that her son's there because she could see his location. Right. And the hospital says, we can't give you any information. And even though it's his own mother, but had he had HIPAA set up, a healthcare power of attorney, she would have been able to fax it over or what have you, and then she would have been able to get information. So that's HIPAA.
Understand. Another term, what is guardianship and when should it be established?
Yeah, so guardianship is for minor children, very important. And, again, you can make the decision, God forbid something happens to you, who's going to be telling your kids what time to go to bed, or you can leave that up to the state. Typically, your guardianship is embedded within your last will and testament, so you could accomplish both of those all in one document.
Okay. Another term, what about a financial or healthcare power of attorney? And also what is a durable power of attorney?
Yep. So financial and healthcare power of attorney are just very simply making those types of decisions for you if you're incapacitated. Financial power of attorney is 37% of the calls that we get are just for that.
Okay.
Which is the majority, when you consider everything.
Right.
And it's very easy to set up. I wouldn't do it online, but that is giving someone permission to pay bills and manage your retirement and what have you if you can't make those decisions yourself. We typically think of someone who maybe they get older, and in that circumstance you're making a decision, but it doesn't always have to be that way. I mean, recently we had a police officer in his 50s. He had a stroke.
Oh boy.
And his wife had no access to his pension or anything else for a year and a half because the financial power of attorney was never established. She could have had access the very next day, but instead she had to go through a guardianship through a court system. So that's why it's important to set up a financial power of attorney. Healthcare is just making healthcare decisions. Durable just means that if you have the document in your hand, you can make those decisions for that person versus a doctor's note saying, okay, this person's incapacitated, so now you can make decisions for them.
Okay. What are typical advanced directives and what is their purpose?
Yeah, so advanced directive is kind of a blanket term. And so it would include your healthcare power of attorney, your living will, and your HIPAA. So it's kind of used synonymously, almost like a copy machine and a Xerox machine, right? We all know what that is.
Xerox, yeah.
So if you use the term, hey, do you have your advanced directives? You're really speaking of those three documents: your healthcare POA, living will, and HIPAA.
Okay. What is a transfer on death affidavit, and is it a good way to avoid probate for real estate?
I'm glad you asked.
Okay.
So a transfer on death is specifically for real estate.
Okay.
And it is one of two ways to avoid probate court for your home or other properties. And it's a document that's usually a couple pages. Typically an attorney would draft it. And it's a less costly way to avoid probate for real estate. And upon death, it will transfer the home to whoever is named. I think that it's a good way if you have an adult child or an adult beneficiary, and only if there's only one child that you're leaving it to, or one beneficiary. The reason I don't like transfer on deaths or TODs, if you have multiple beneficiaries, is because now not only do they have to agree on the sale price, but so do their spouses, because their spouses have dower. So hypothetically, very common scenario, husband, wife, they have 3 kids, jointly titled home, it'll go to the survivor, no problem, no probate. When both of them pass away, if they do a transfer on death, now all 3 of their kids have to agree on that sale price. In that scenario, statistically, not all of them get along.
Difficult.
Yep. And then you throw in spouses, and so now you have 6 people who have to agree. And chances are one of them has an opinion about whether or not the kitchen should be redone, or what have you. So the better way for real estate is to do a trust where one person is in charge, because in that way it avoids probate court and you avoid those dower rights.
Okay. Well, in graphic D, I asked the question, what is a trust? What's put in the trust? And what advantages does the trust have over a simple will? That's a simple question.
Yeah. So let's start with what is a trust. It is a document that tells the world who gets what, just like a will. Okay. It puts someone in charge, just like a will. So it's a contract to the world of what's going to happen with your assets after you pass. However, a big distinction between a will and a trust. A trust avoids probate court as where a will does not. Okay.
Wonderful.
The bigger distinction is a trust will protect assets for your beneficiaries. So a couple of examples. You're married, kids, but maybe you have a child who's irresponsible. Maybe you have a child with creditor issues. Maybe a child's going through a divorce. Well, if you're using your will, or if you just name someone as beneficiary on your IRA or your investment account, they get that money outright, and there's no protection. And that's the point of the trust, is you've worked your whole life, preserving this legacy, this nest egg, and it's going to go to your family or whoever it is that you choose. Why not protect it? And so that's the purpose of the trust. So instead of the assets going directly to the beneficiary at first, it goes to, let's call it the trust bucket. The beneficiaries can take, money out as they need it. And so long as the assets are in that trust, it's protected from the world. It's protected from creditors, litigation, divorce. Divorce being the biggest one. I actually just saw this yesterday. So now the new stat, 56% of people are getting divorced. And so if you can imagine, if you have 3 kids, you have a pretty good probability that one of them is going to get divorced. If they get an inheritance, they throw that money in their joint bank account, there's no protection. So the divorce would ensure that all of that, is protected. There's many different reasons for having a divorce. I've named a few, a trust, I've named a few. Some others might be if you have a special needs child, that child cannot legally inherit, so you have to have a trust.
Right.
Of course, if you have minor beneficiaries, but again, even if you have a 19-year-old child, would you want that child inheriting $1 million? Probably not.
Yeah.
As they get older, if they're in their 30s or 40s, so now we're really looking after them for creditors, litigation, divorce, things like that. And then even further on, if we're 65 or older, now a trust might be used for long-term care purposes, so ensuring that a nursing home or what have you isn't taking our assets. And that's how a trust can help.
Okay. Now, another graphic, graphic E, what is a family trust and what are the advantages it has over a trust or a will?
So I'm glad you asked that, because there's a lot of buzzwords out there. So you have like family trust and legacy trust, heritage trust.
Okay.
And they all mean the same. You can call it whatever you want. And we call it a family trust in our firm. And, I've listed out all the reasons why you should have one, the advantages of having one. But the bottom line is your trust is you start off by either having it revocable or irrevocable, meaning that you can make changes or you cannot.
Okay.
And then, of course, all the advantages listing there, we call it a family trust, because you're trying to keep those assets within the family. You don't want a spouse or a creditor or someone else attaching their interest in your assets. So that's what a family trust is. It's bloodline, keeping everything in the family. But you can call it, many different terms.
I see. Okay. What about the treatment of minor children in a family trust?
So minor children, of course, they legally cannot inherit.
Right.
And so it's very important to have a family trust so that the assets go to someone other than the minor through avoiding probate court. Quick example, we have a case right now, it's ongoing, it's been about 2.5 years. And young guy passed away, and he's in his 40s, left behind a 3 and a 6-year-old.
Wow.
He unfortunately did not have a trust, and he tried to do the right thing, and so he got some life insurance. But the big mistake he made, a couple $1 million in life insurance, which is what I would have done too, but he named his minor children as the beneficiaries.
Ooh.
He can't do that. So everything's going through probate court. Well, the problem is they can't inherit, and then moreover, he accidentally disinherited the mother of the children because he didn't have the trust. So now the mother of the children has to ask for every penny, and oh, by the way, she can't use that money to care for food and shelter because she has an obligation to do that for the kids anyway. So in terms of guardianship within the trust, that's the whole purpose. You talk about, when should we start? If you're thinking of having children, you should set up a family trust right away, because that's where the assets will go under the control of whoever you want, but instead of it getting tied up in court.
Okay. And I think you've answered this question already. When is an irrevocable trust needed?
Sure. So in a couple of circumstances, either if you are planning for long-term care or if you are high net worth. And high net worth is kind of relative, but the estate tax exemption right now is $15 million, meaning that you don't have to pay taxes unless, federal tax, unless it's over $15 million.
Okay.
So I'll start with that one. If you're over $15 million, then an irrevocable trust, I think is appropriate for many reasons, and mainly taxes, but also privacy. Because if you're in that category and you create the irrevocable trust, your name's not on anything. You're giving up some control to gain that, but that's where it's used. The irrevocable trust most commonly is used in a long-term care scenario. So hypothetically, if you have someone who has $500,000 in assets, and let's call it in the bank, just in the bank, and then they have a $300,000 house, and they're 65 or older. Well, if they go to a nursing home, how do they pay for it? They're going to pay that $500,000 that's in the bank, and then once they pay it down to nothing, now they're broke, and now Medicaid will pay for them. So what does Medicaid do? They put a lien on your house. So you could create an irrevocable trust to take it out of that equation so that when Medicaid goes to put a lien on the house, you don't own it, the trust does. And so now you're able to protect that asset for your kids. Same example, if someone has $3 million in assets, I don't think the irrevocable trust is necessary, in my opinion, because they're self-insured.
Okay. Does the size of an estate dictate the need for a trust?
Absolutely not. So I hear this all the time. It makes my blood boil when a financial planner or a CPA might tell their clients, you don't need a trust because you need $5 million or more. The amount makes no difference. It depends on what your goal is. If you don't want the government or a nursing home taking your assets, if you have 500,000 or less, and that's just a number, you could have 200 or $1 million, it doesn't matter, then a trust is appropriate. If you have minor children, a trust is appropriate. Irresponsible children, a trust is appropriate. If you're worried about creditors, litigation, someone who has spent their whole life and, they've saved up a $250,000, versus someone who has $2 million, it still means the same to them, right? That the dollar amount doesn't matter. They want to make sure that it's protected for their kids and it has the best tax implications and so forth. And so, yes, the dollar amount does not matter. A trust is appropriate in many circumstances.
Okay. When should a family trust be reviewed and updated?
I think that any trust or will, anyone's plan, regardless of what you've done, so whether you have a trust or not, that annually you should review it. And that doesn't mean that you have to go and see a lawyer. So we send out an email once a year to our clients, and we're like, hey, have any of these things changed? And I actually just sent it out to, many people. And a few people responded and said, oh yeah, I've had this change in life. But you can do your own internal audit And, the things that you should ask yourself, have any addresses changed? Any new additions to the family? Any divorces? Has anyone passed away?
Big things.
Big things, yeah. So if any of those things have changed, then yeah, you might go and talk to your lawyer to get an update. Overall, the document itself, the laws don't change, very often. I've been an attorney 10 or 11 years now, and I've had two, big changes where I had to go back to the trust and just to review things. And overall, most people didn't need a change at all. But every year, take a internal audit of what's going on, and then I would say every 5 to 10 years to talk to your attorney to do a formal review.
Okay. Tell us about long-term care planning and what needs to be added to a family trust.
Yes. So as we briefly talked about earlier, so what is long-term care or LTC? It's as we get older, if we need additional assistance, maybe it's independent living, assisted living, nursing home, that's long-term care. How do we pay for it here in Ohio? Well, Medicare will pay for the first 100 days. And then after that, you are paying out of pocket. And you may have gotten postcards in the mail or you see these dinner presentations. I don't really get involved too much with that, but I'll give it to you straight. It's expensive. And that's what people are reaching out to you to come to these events to learn how to save. So the average, and I'm rounding here, but it's about $10,000 a month if you're looking at a nursing home, right? And so in terms of the family trust, a way that you can utilize a trust to prevent that is actually creating a separate one, the irrevocable trust, putting your house into that so that if you do have a spend down, at least you're preserving the house so that it's not getting taken by nursing home or so forth.
Okay. What is the 5-year look-back period and how can it affect an estate?
Yes, 5-year look-back. This means that if you have a long-term care event, and if you go to a nursing home, you're paying out of pocket, right? They look back 5 years to see if anything that you've done, especially if you've gifted money away, if you're applying for Medicaid. I'll give you an example and it'll make sense. I have a client a few years ago, and it was in Parma, and mom goes to a nursing home, and she had roughly $300,000, okay? Worked her whole life for it. And 2 kids. And so what she did when she goes to the nursing home is she wrote her 2 kids checks for $150,000 apiece. And so then she went to the nursing home and she says, hey, I'm broke. I don't have any money, so put me on Medicaid. And they said, no problem. We need 5 years of statements. And so, of course, they caught it. And they says, well, you're not eligible for Medicaid because you gifted this money last month to your kids. Well, in that scenario, the one daughter still had the money, but the son, who's out in California, he spent it. And so it created quite a problem. And so that's what the 5-year look back is. You can't, and I'm not saying, as we get older that you can't spend your money, because you should do that. If you make gifts for Christmas and whatnot, you could still do that. But you can't, if you have a long-term care event, you can't just give your money away because under the law, you have to spend it on your care. And that's the purpose of meeting with an attorney, so that you can reduce that spend down as much as possible.
Okay. Again, a graphic F. What are the characteristics of a house trust and when is it necessary?
Yes, so exactly what we have been kind of touching on, house trust or irrevocable trust. I like to call it the house trust because if we're specifically talking about long-term care, generally speaking, the primary asset that we would put into that irrevocable trust is the home. And the reason why is your other assets, you can't just move an IRA into an irrevocable trust. You would first have to cash it in, pay the taxes, and not only that, but you're living off of that retirement money. This is a really good point because there are different philosophies on long-term care and how to pay for it and how it relates to an irrevocable trust. Just as we're doing this here now, if you turn the TV on Saturday or Sunday mornings, you will see some other attorneys doing a commercial, and they want you to take all of your money and to put it into one of these trusts. You can do that. That's not what I would do because I feel that you should be enjoying your retirement,
You bet.
instead of giving up control of all of it. Because essentially what that does is if you give up 100%, on paper, yes, you're broke. But then that means that your only option is to go to a Medicaid run facility. And I don't know about you, but for my parents, I would at least want the option. I've done one of the, not to breach confidentiality, but my parents don't care. I've done one of these trusts, for my parents, but I certainly did not put all of their money into one of these irrevocable trusts. The house trust, it's mainly for the house. At bare minimum, it depends on what your financial circumstances are, but this will allow you to avoid probate, prevent it from going to a nursing home, and you're at least passing on the house to your kids.
Okay. What about business succession plans and preserving the value of a business for the future?
Yeah, so business owners, very important. Business owners don't realize that their business needs to have its own estate plan, its own succession plan.
Okay.
Whether it's a sole member LLC or multi-member corporation, maybe you have shares in a certain company. All of that matters because if you don't take that business and create a succession plan, then it ends up in probate court and you're losing a ton of money and a ton of time. Take your average family business. Maybe it's a mom and pop grocery store.
Right.
Okay. Business is in dad's name, hypothetically. He passes, mom, son wants to go and take over the bank account. They can't. The bank is not going to let them on the account. And then you have to spend 6 months to a year where if you have a proper succession plan through the business, it can be a seamless process in the matter of days, business as usual. We're part of an organization, and so other attorneys will call us where property ends up in foreclosure, and a lot of them are in businesses. Maybe someone had a rental property. Because there was no plan, there's one in particular I'm thinking of now. This probate estate had 15 properties. It was over $1 million. They're kind of smaller houses.
Right.
Well, 6 or 7 years went by before everything was foreclosed on.
Oh, boy.
There's only $80,000 left out of over $1 million.
That's too bad.
Because there was no planning.
Sure. Okay. What are the components of lifetime support that your firm offers, and how much does that cost?
So
that's slide G.
Our lifetime support program. Actually, so we used to charge for this, but we don't anymore. And
well, thank you.
Yeah. Yeah, I am a business owner, and so everyone's trying to get those annual fees, right? We don't charge for it anymore, but basically, if you become one of our clients, we, of course, will answer any questions that you have. We don't charge for it. We'll talk on the phone, and we will update any address, phone number, what have you. We don't charge to update those types of changes. So if it's a bigger change, then, of course we do. But the bottom line is we're here for life. This isn't a one and done. We try and, be your family attorney. I think you're going to ask me in a little bit about, what we specialize in, but I'll tell you, I don't do divorce. I don't do criminal law or patent law. And, but if you call us and say, hey, I have this problem, in our network, we will refer someone who we know, like, and trust. And so we're here for anything that you need.
Okay, that's good. What's your firm's website?
Sure. BaronLawCleveland.com. So pretty simple. If you type in Baron Law, we pop right up.
Okay. Where is your headquarters office?
Independence is home base, but we have offices in Westlake, Beechwood, and then also Columbus. And so I personally, as well as our associate attorneys, kind of float around, just like a doctor or a dentist would, to try and serve the needs of the local communities.
Okay. How can you be contacted? Telephone number, email?
Yeah. If you want to talk to someone right away, just call the office line, 216-573-2373. Or Dan at BaronLawCleveland.com. You talk to our client liaison, or you can get in touch with an attorney. We're pretty easy to get a hold of.
Okay. In summary, and I think there's a graphic that addresses this, what makes sense to you and what doesn't?
It makes sense when you have something as serious and important as estate planning that you meet with a professional. It's not a do it yourself. Just like, I use the analogy of going on WebMD to try and, figure out whatever.
Diagnose your illness.
Yeah, it just that just doesn't make sense. Also, what doesn't make sense is one size doesn't fit all. Everyone's circumstances are different. And you asked about my day to day. Who I met with at 9 o'clock in the morning, their situation is totally different than the person I met with in the very next meeting. Married, divorced, kids, no kids, business owner, all of that, it makes a difference. And that's why you can't just go online and say, oh, I've got a will, I'm good. No, you don't realize that you're going to probate. Right? I mean, sure, the internet will ask you a couple of questions, but it's the questions that aren't asked. Those are the questions that you're going to get with meeting a professional. So it makes sense to meet with someone. It doesn't make sense to do it on your own.
Okay, well, I remember your motto about peace of mind. And,
yes.
And talking to you folks and talking to you certainly gives you peace of mind. And it's a complicated situation. I know if people look at your website, it's very informative, and it's something that really needs to be done. If you want things to go the way you want, you need to talk with a professional like you. And I know that you're very ethical, and you run a very good organization. And I want to thank you for watching. Please give us feedback on the show. You can ask questions, make comments. Our email addresses will be on the bottom of the screen. If you're interested in appearing on the show, or an interesting person who you think would be on the show, please just get us their contact information, and we'll take it from there. And remember, seatbelts save lives.